4CRB 89.3 FM, your radio station.
And a very good morning to you. It's John Fradgley from the Bell Legal Group, back with you for another program of The Law and You, the second program for the year. This is your opportunity to get free legal advice between now and 9:30. That's, of course, 10:30 Tweed Coast time. All we ask you to do is get on that telephone as soon as you possibly can. Our number, 55208888. That number again, 55208888. Don't forget, if you live south of the Tweed River, you'll need to put 07 in front of that number if you're wanting to ring. But otherwise, anywhere north of the Tweed River and up through Queensland, 55208888, and you'll get straight through. Thank you to all the people who called in last week. We certainly had an interesting program. Not a lot of calls last week. I think from memory there were only about 3 or 4 calls, but nonetheless very interesting. A couple of questions raised, which I hope not only helped the people who called in, but were also useful to other callers. You may remember that our first caller last week, John, was querying the situation in relation to dividing fences between bodies corporate, and he was the secretary, I think, from memory, of a body corporate, and there's a body corporate development also next door, and he was querying whether the dividing fences legislation, which of course in Queensland now comes under the Neighbourhood Disputes Dividing Fences and Trees Act 2011, nothing like a short title for an act, and that's nothing like a short title. Well, that legislation certainly does apply. The question, though, that is a little less clear, John, is whether that legislation applies to retaining walls, because I think from memory you mentioned that there was a tree on the adjoining property which was damaging the retaining wall. And so I think the situation is that I would still be giving notice to the adjoining body corporate to fix the problem, and if they don't do anything about it, I would be issuing them with a notice. And then taking the matter to the Queensland Civil and Administrative Tribunal, because the Tribunal does have the power to make orders in relation to problems with trees and dividing fences, and in some circumstances that can include retaining walls. But enough of that. We've got callers coming in, so we say a very good morning to Fran. G'day, Fran. How are you today?
Yes.
Hello, Fran. How are you?
Thank you.
How can we help today?
I just want to ask one question.
Sure.
If somebody dies intestate, how long does it take before all their assets and what have you are all... I know it's a terrible thing to do, but I have somebody close to me who... my daughter, who I've been asking to do her will, is putting it off, and in this day and age, one doesn't know what's going to happen in the future. So if she died intestate, how long does it take for all things to be finalised?
Right, okay. Well, it would depend on what her assets were, Fran. So
house, basically. House, car.
Right, okay. So unfortunately, because there's a house involved, you would probably have to apply, or you would have to apply. Is this in Queensland, by the way?
Yes, Queensland, yes.
So you would have to apply for letters of administration. So that application would be made by someone, a close relative of your daughter. So is she married or not?
No.
No, okay. So
no.
More than likely, and has no children?
And I am the beneficiary, supposedly, but I'm not, because there's no will.
And she has no children?
No.
Right, okay, yes. Well, look, you would then be well placed to apply for letters of administration. And does she have any siblings?
No.
Right, okay.
No.
In those circumstances, then, from memory, under the rules of intestacy, you would take, or you and her father would take, as the...
Well, her father has no claim to stake the claim, because the property was actually mine, my money, and he's been gone for 30 years. So
he's passed away?
No, he hasn't, but he's been repartnered.
Right. Well, unfortunately, he would probably still be in the loop in terms of the rules of intestacy.
Oh.
So if there is any reason why your daughter should make a will, that's it.
Yep.
So you'd better let her know that unless she wants her estate to end up in, I think it would be 50-50 to you and to your husband, her father, that could be a very nasty outcome. So
very nasty.
So
indeed.
I would suggest that you tell her, hey, you need to get a will made and do it ASAP.
Exactly. I can't stand it. I've done mine, which protects her, but she needs to reciprocate.
Yes, I think that's only fair, Fran.
Thank you very much.
Okay, then, all the very best. And the time on 4CRB is just coming up to 9:11. This is The Law and You on 4CRB, your chance to get free legal advice between now and 9:30. That's 10:30 New South Wales time. All you need to do is get on that telephone straight away. 55208888 is the number. We say a very good morning to Noreen. G'day, Noreen. How are you today?
Good, thank you.
How can we help you today?
Yeah, I'm a bit worried about my brother. He has a partner. They've been together for about 5 years. And in his will, he did make out that she could stay in his house till, if he passed away, till such time she couldn't look after it anymore. And that was fine. Then it was to be sold and divided between her and his siblings. But then they decided to sell his house and move into a retirement village. Now, for her to stay in that retirement village after Bob died, the name had to go on the deed of that complex.
Yes.
So they told him that it would still be the same if they were still in the other house, that it would go back into his estate when she passed on or couldn't look after it anymore. I don't think that's the case, is it?
I don't think it is either. Is this in Queensland?
Yes.
Yeah. No, well, look, to the best of my knowledge, none of those retirement complexes allow for you to own... Is it one where you get freehold title or is it a leasehold?
I'm not sure.
Because, see, if most of them, to the best of my knowledge, the ownership is when a couple go in as joint tenants, which means that the retirement village apartment or whatever it is automatically devolves on the surviving joint owner, regardless of what the will says, which means that it becomes the surviving owner's asset solely. So, he could possibly investigate whether it is possible to do it as tenants in common and then for him to leave her a life interest, but that would very much depend on the complex they're in and whether they allow ownership as tenants in common. I mean, theoretically, if, for example, it were a freehold title in a retirement village, then it would be possible, or it should be possible, to do tenancy in common. It may be possible to do tenancy in common on a lease. If it's a leasehold, I'm not sure. But certainly he really needs to look at that pretty carefully if he's serious about wanting his siblings to receive anything after his passing or after the passing of his partner. And the other thing, of course, that needs to be considered too, how long did you say they've been together now?
About 5 years.
Yeah, so they're now in a de facto relationship, and so she would be able to bring a claim against his estate unless they've entered into a binding financial agreement, which says that, she won't make any claim on his estate, but she would be entitled to make a claim on his estate as his surviving de facto spouse. So, there's a lot of issues there that he really needs to think about.
Yeah. Yeah, it just worries that they go in with nothing and walk away with everything.
That's exactly right, yes. And I've seen it happen time and time again, so it is something to worry about. And people really need to look at these issues seriously if they want to maintain their intentions in relation to their wills, etc. Okay?
Okay, so
all the best. And the time just keeps rolling along, 15 minutes past 9, past 10 Tweed Coast time. We say a very good morning to Roy. G'day, Roy. How are you? Roy, are you there?
Yes.
G'day, Roy. How are you going?
I'm here, yeah.
Yep. How are you?
I'm fine, thank you.
That's good. How can I help you today?
Yes. I'd like to talk about, ask you about, have you got me?
Yep, sure have.
Great. Wills for persons
Roy,
who have
Roy,
assets. Yes?
you've apparently got your radio on in the background, and we're on delay, so it'll be driving you crazy.
Absolutely.
I suggest
Okay.
you
I
turn
think
the
it's
radio
off
off. Okay, that's
It's
better.
off now?
Okay,
That's
great.
better. Okay. John,
Yes.
wills for persons who have assets in different countries.
Yep.
Whether one should have different wills for different countries.
Mm-hmm.
I understand that the big advantage of doing that is that when it comes to administering the estate, it does make for a quicker, a more efficient process and helps
Yes.
the executors.
Yep.
Can I have your ideas and opinions on this, please?
Right. Well,
Yeah.
you've got two options when you have assets in other jurisdictions. You can either do a will in each jurisdiction. When you do that, though, you've got to make it very clear in the will that it is limited to that jurisdiction, and that the revocation clause in the will is limited solely to any will you've previously made in relation to that jurisdiction, so that you don't unwittingly revoke a will for example, Britain by doing a new will in Australia. So that's if you have a situation where you have someone who can act as executor in those jurisdictions, then that can sometimes be a good way to go. The only thing that you may need to consider is the cost of obtaining probate, if it's necessary to get probate in each of those jurisdictions. The other reason why people often do wills that are limited to a jurisdiction is because if the other jurisdiction has death duties which apply worldwide, and I've seen this happen with South Africa, where people particularly do not want to have an international will or an Australian will applying to their assets in South Africa, because it can bring those assets into their Australian assets into question in determining death duties in the other jurisdictions. So the other option is to do an international will. And there is a convention or a protocol that's in place which specifies the jurisdictions that will that now are part of that covenant for international wills, and this can sometimes make the administration of the estate in various jurisdictions much easier. So it's very much a case-by-case basis, Roy, in looking at your circumstances, where you've got assets, what, if any, idiosyncrasies there are in those particular jurisdictions, whether there are death duties that need to be considered, and how they're going to apply in terms of international assets. All right then?
Yeah, well, probate has to be applied for. The grant of probate needs to be applied for in every individual jurisdiction.
Either a grant of probate or a reseal, depending on the circumstances.
Can you explain briefly what a reseal is, please?
Well, a reseal is where you've obtained probate in a particular jurisdiction, and then you're needing to use that will in another jurisdiction. You may be able to apply for what's called a reseal of the probate, which in other words means that the other jurisdiction will acknowledge the probate that has been granted elsewhere, and will simply reseal it in their jurisdiction to say, we accept the grant of probate from this jurisdiction, and we reseal it in this jurisdiction so it can be used here. It's just a simpler process.
Okay. All right.
right.
Maybe we need to make an appointment to come and see you.
All right, Roy. Well, I'll leave that to you.
Yeah, thanks very much.
Okay, then, all the very best. Time on 4CRB, 19 and a half minutes past 10, past 10 south of the Tweed. And we say good morning to Nan. G'day, Nan. How are you today? Sorry? Ivan, was it? Oh, hello. Sorry, Ivan. I could have sworn I saw Nan, but it's Ivan.
Ivan,
yeah,
hi,
sorry.
John. I just want to check on some accuracy.
Sure.
The accuracy of some advice my daughter received. Her divorce was finalised 6 months ago, and the solicitor told her that if they didn't have a property settlement or anything, and they both really had nothing, and then the solicitor said that if her ex-husband did not apply for a settlement or come to her for anything within a year and a day or a year and a year and a month that he could not come to her for anything in the future, and she's starting a business, so she just wants to make sure that that's accurate.
Well, there's basically a maximum period of 12 months, I think it is. It might be 12 months and 1 day. I don't practice in family law, but there is a period of 12 months from the decree absolute within which an application for property settlement can be brought. There is the ability to apply for an extension of that time limit, but you've got to be able to show very good reasons why you should be given an extension of time. So essentially, once that 12 months is over, then it's not possible to bring an application.
Okay, so that information shows she'd be safe to go ahead with the business, and he can't come and claim on.
Well, you said they were only divorced 6 months ago, so there's still 6 months to go. But look, that all being said, they look more at the assets that they had at the time the divorce took place. So, I think it'd be a bit of a long bow to try and bring an application now. But nonetheless, to be on the safe side, you would wait the 12 months.
Okay,
right.
I just remember another friend of mine that was divorced, and about 4 years later, his wife came and got her solicitor wanted to reopen. They'd never gone through the family law court, and he had to end up paying her after about 3 or 4 years after the divorce was settled.
I find that quite strange because, my clear understanding is, you can bring a property settlement application immediately after you separate, and the only time it can be reopened is if you haven't been truthful in the information you've given, and they subsequently discover that you had more assets than you claimed you did. But certainly my understanding is that the time limit is 12 months.
Okay, all right. Thanks so much for that.
Okay, then, all the very best. Time on 4CRB, 22 and a half minutes past 9, and we say a very good morning to Steve. G'day, Steve. How are you today? Are you there, Steve?
Yes, waiting.
How can I help you today, Steve?
Oh, good morning. Is that John?
It is indeed.
Oh, John, I have a cousin in the UK, and he's just let me know that he's made me the sole beneficiary of his will. He has a half brother, but whom he doesn't wish to leave anything to because he hasn't shown up very well in the past. And I'm just wondering, can the half brother contest the will?
Look, Steve, to the best of my knowledge, the law in the UK in relation to those who can bring an application is the same as Australia. And unless the half-brother was being supported by your cousin, then certainly under Australian law he would not be able to bring a claim, because the only persons under Australian law who can apply are a spouse or a child or someone who was supported by the deceased at the time of their passing. And I'm 99% sure that the law in the UK is the same, because our law is derived from there. But what you could do is get on the internet, if you like, and just take a look at who can bring a claim in the UK, and I think you'd find the answer to that question. And I'd be almost confident that it is what I've told you.
Oh, thank you.
Okay then. Okay, Steve, all the very best. Time on 4CRB, 24 minutes past 9, and we say a very good morning to George. G'day, George. How are you? Are you there, George?
Yes.
How can I help you today?
My question regarding body corporate. I own a building in a body corporate. There are 3 people in that building. I have a fairly large building on the block, so there's another person the same size. And then the third tenant in that, the third owner, is a car yard. And his building isn't as big as ours, but he has a big area because of the car yard. Now, he's going to knock down his smaller building and going to extend. What rights do we have in that body corporate if we were to be sort of built out towards the street? What are our rights in that regard regarding the building he might build? Do we have any say in that at all?
So is the lot, in other words, the yard that the car yard is on, is that part of his lot?
It is.
Right.
Yes.
Okay. So it was actually a group title development by the sound of it.
It must have been.
Okay. Yeah.
And we're running our own body corporate. You see.
Well, I think what you'd need to do is firstly take a look at what the original plan provided, what the original approval was for, and then it would be a question of whether the council would allow that redevelopment. I honestly don't know whether you would be able to take any action if it's going to block the view that your premises have of the street.
Yes.
What I would suggest you do in relation to it, quite honestly, George, is I would be getting in touch with the town planner and having a word with the town planner in relation to it, because really you'd have to know where the development is, what the original approval was, etc. There'd be a lot of information that you would need before you could say anything definitive on that. So I think if you and the other owner get together and share the cost of going to a town planner, I think you'll find that's a better way to get some appropriate advice.
I see. And is that the council town planner?
No. I think that you could try and talk to the council town planning officers, but I think you might be better to talk to consult a private town planner.
I see. Thank you.
Start with the council if you like. Go and see them and see what you can find out, what they'll tell you, and if you and depending on whether you get assurance from them or not, you can make a decision as to whether you should take it further.
I see. Yeah.
All right.
One further question.
Sure.
The person who sold the car yard, he was doing the body corporate, and I haven't taken it on, and the other person doesn't want to take it on, because it's internet banking, and it's a bit beyond me.
Yep.
Could we go back to paying our accounts with cheques and having two signatures on it?
Well, certainly a body corporate account can operate off a cheque account. There's no reason why you need to do it by the internet. So,
I see.
Yes, no, that wouldn't be a problem at all.
I see. Thanks very much.
Okay then, George, all the best.
Good.
And the time is 27 minutes past 9. We'll say a very quick hello to Doris, but Doris, we'll have to make it quick because we're pressing up to the news. Hi Doris, how are you today?
Good, thank you, John. I wonder if you can help me, please. I sold my house over in Mermaid Waters about 4 years ago, and I put it into this big house over in Broadbeach Waters with a granny flat on. But then my son took out a small loan with the Suncorp, so my name went on to the deeds of the house. It's got 3 names on, and it's all paid up now, though. But I'm wondering whether my son down in Adelaide would be able to come back on this house after I died.
It would depend. Do you know how the title is held, Doris? Is it joint tenants or tenants in common?
I think it's just got 3 names on it.
Yes, I know, but if you've got 3 names, you can either hold it as joint tenants or you can hold it as tenants in common. If it's held as joint tenants, then the property will automatically devolve on the surviving joint owner. If it's held as tenants in common, then your share of the house can be left under your will to whomever you please. So the son who's down in Adelaide, he's not one of the ones who's presently on the title?
No, I haven't seen him for years.
So the only way that he can make a claim on your estate is assets that are in your estate. So if that property was held as joint tenants, then your share of the house would not form part of your estate on your death, because your share of the house would go to the surviving joint tenants. So what I would suggest you do is go and see your solicitor, and get them to review the title to the property to see how it's held. And it very well may be in your best interest to convert, if the title presently is tenants in common, may be worthwhile converting that to joint tenants.
Yeah, I wondered whether I could have, if that is the case, I could have my name took off, you know?
Well, you might be easier just to make it joint tenants, because then you don't have to worry, but you won't have to pay stamp duty or anything. So just have a word to your solicitor about it, but I'm sure there will be a solution. All right then? Okay, Doris, all the very best. Well, thank you to all the people who've called in this morning and made for such an interesting program, certainly many and varied calls. I'll look forward to being back with you again next week for another program of The Law and You. So until then, as always, this is John Fradgley from the Bell Legal Group. Goodbye and God bless.